Welcome to Colorado Criminal Defense with James Colgan.
From the Front Range to the courtroom, this is Colorado Criminal Defense with James Colgan. Welcome back. I'm Lisa Mosbey, your host. When your freedom and reputation are on the line, experience is the only thing that matters. In each episode, we go behind the scenes of the justice system with James, a seasoned defense attorney dedicated to fighting for the accused across the state of Colorado. Whether you're facing charges or just want to understand your legal options, you're in the right place. Let's dive in. James, thank you so much for joining me today.
Thank you, Lisa. Good morning.
Good morning. James, in Colorado, what is the legal difference between a standard battery and one that carries a domestic violence designation, especially regarding firearm rights and maybe professional licensing?
That's a good question. We kind of discussed this in a previous discussion about what they call collateral consequences of a criminal conviction or plea. And domestic violence is a huge example of the collateral consequences. With most bar fights, you get in a fist fight in a bar, you serve your punishment, you move on. It might be a small blip in your record, but it's not that simple with domestic violence. You're right. Because of the Brady bill, if we remember James Brady when he was shot, there's federal legislation that says if you have a domestic violence conviction, regardless of whether it's a misdemeanor or a felony, you lose your right to own a weapon. So that's obviously a huge collateral consequence for people that are hunters or people that like to keep guns for home safety. In addition, a domestic violence conviction, for the most part, cannot be removed from your record. Many misdemeanors, you can seal your record, get it removed from your record so that if you apply for a job, no one knows about it. You can't do that with a domestic violence conviction. Plus, domestic violence is not a crime in and of itself. It's a sentence enhancer, which requires you to attend usually up to 36 weeks, at least in Colorado, up to 36 weeks of treatment, counseling, and that kind of thing. So it has huge consequences if you plead to a domestic violence conviction.
And then in a heated situation where both parties have scratches and bruises, how do Colorado officers decide who to arrest?
Well, they just basically, if you remember the term probable cause, it really is, in order to arrest, it has to be more probable than not that one person caused the incident. So that's kind of the instinct that police officers use. They say, in my professional opinion, this is the person that started it. So that's the person that gets arrested. And to be honest with you, the majority of the times, if it's a mutual type of fight between a man and a woman, most oftentimes the man is the one that gets charged.
And James, many people believe that if a spouse or a partner doesn't want to press charges, the case is over. Can you explain why Colorado's mandatory arrest policy means the police, not the alleged victim, make the final call at the scene?
Well, the police make the call, as well as the prosecutors, once the case gets to either the city attorney's office or the district attorney's office. Basically, the way they view it is the case is now in the system, and the decision to prosecute the case becomes the DA's decision, not the victim's decision. So very often, depending on the type of evidence that exists, you can still get prosecuted for assault and domestic violence, even if the victim doesn't wish to participate or cooperate.
James, can you explain to our listeners how someone who has been arrested on domestic violence charges, how their answers or even their silence impacts the case?
Well, basically, what people need to realize is that domestic violence isn't any different than any other crime. Anything you say to the police, including small things, can be used against you and can be manipulated against you in a court of law. But your silence can't be used against you. You have a constitutional right not to speak to the police. Even if you're out of custody, you can simply say, I am not speaking to you, and you have a constitutional right not to do so. They cannot use your silence against you in a court of law.
But we know there's something they can use against us in a court of law, and that's if we're talking too much. Isn't that
That's if you're
correct?
talking. And very few of my clients do not talk to the police. And, and you can see why. When the police show up at a scene, very often people are like, well, I have nothing to hide. I'll be happy to cooperate. But the problem is you do not know what the police think they know. And sometimes it may be inconsistent. And then all of a sudden your words can get twisted and make it look like you're not telling the truth when in fact you're just telling your side of the story. So that's why I always encourage my clients not to talk to the police if they can avoid it.
And then, why is someone who has been arrested on a domestic violence charge required to sit in jail until they see a judge?
It's a cooling off period. The belief is that if you get arrested, say at 10 o'clock at night, you stay in jail to kind of cool off, and then you see a judge the next morning, because there's also mandatory protection orders that go into place so that you are informed on paper that you are to stay away from this person. You are not to have contact with this person. It's the judicial system's effort to kind of let everything drop down a level and everybody can try and be a little calmer about the situation. Because as you can probably imagine, all these domestic violence situations are very often volatile, and a lot of screaming, oftentimes drug or alcohol use. And that period overnight has proven to be relatively successful in calming the situation and home down.
And you mentioned mandatory protection order. Can you tell us what that is, and how does this order effectively evict someone from their own home before they've been convicted?
That is a complication. That is a complication. It's that can get very complex. I've had situations where um, somebody was staying with them as a guest, and they were arrested, and they got thrown out of their own home, even though the other person didn't have any property rights to the home. They were simply a guest that was in from out of town. So believe it or not, sometimes you have to actually go to the effort of evicting somebody from a house so that you can go back into your own home. I've had to do that a few times. But you're right, it complicates things because the mandatory protection order keeps you out of that home, and the police or the court system very rarely go into who actually owns the home, who has property rights. The mandatory protection order just says you can't go to this particular piece of property, and you've got to litigate to get you back into the property because it's your house and they don't have rights. So it becomes very complicated.
So there's no set amount of time that you can't go back. You actually have to go to litigation to get permission
Well,
to return to your house?
n- not always, not always.
Okay.
Sometimes people will voluntarily move out of there. But then, of course, you do have the situations where it's a man and a wife situation where both people have property rights. And if both people have rights to the property, the person charged is the one that's going to have to find an extended stay hotel to live at for a while.
Can you tell our listeners how a case can change if the alleged domestic violence act occurred in the presence of a child?
Well, that is a sentence enhancer, and it's considered child abuse if you commit an act of violence in front of a child. And I think the thought behind the whole statute is that it discourages parents or spouses from fighting in front of children if they know that they can expose their children to violence and frankly children shouldn't be exposed to. So I think that's the thought process behind that statute.
And I've heard you use this term before, but let's give a definition to our audience today. Sentence enhancer. What is that, and what other things qualify as a sentence enhancer?
Sentence enhancers are decisions made by either the judge or agreed upon or a decision made by a jury. And those kind of things is the crime charged an act of domestic violence? Sometimes that's put in front of a jury. Is it a crime of violence? That's extremely important because if it's a crime of violence, if it's a defined crime of violence by the legislature, that means that there are enhanced prison sentences, much longer prison sentences, and you have to serve a larger percentage of that sentence. For example, with a crime of violence, um, let's say an assault with a gun. Let's just use that as an example. If you're found guilty of a crime of violence with an assault with a gun, you would have to serve roughly 75 to 85% of your sentence. Whereas if it's a regular crime without a crime of violence, let's just say a felony menacing where you shoot a gun at somebody, that is not a crime of violence. On the whole, if you had to serve the prison sentence, you'd serve about 40% of your sentence. So basically, it adds about anywhere from 35 to 45% of your sentence that you'd have to serve because of that designation. That's just one example there. Domestic violence is a sentence enhancer because of all the increased treatment that you're going to be required to do. Um, there are quite a few. Like there's the use of an automatic weapon is a sentence enhancer. AR-15, you've all heard that term. That is a sentence enhancer that can require additional prison. So that's what a sentence enhancer is.
So, James, for a professional with no prior record, what does success look like in a domestic violence case? Is it a dismissal through a pretrial division program, better than a not guilty verdict at trial?
Yes, yes. I mean, and the
Okay.
reason is that the reason that if you can get a case dismissed prior to trial, you don't have to run the risk of someone else deciding your future. A jury
Yeah.
are 6 to 12 people that don't know you. They don't know your life. They don't know what you've done with your life to get to this point, and they're making decisions about you that could easily affect your professional career. If they, for example, find you guilty and it's a domestic case and you're a medical doctor, there could very well be discipline. I know there's going to be discipline if you're a lawyer and you're charged and a jury finds you guilty. So, yes, anytime you have a professional person that is subject to regulation through a licensing committee, such as DORA, which is the Department of Regulatory Agencies, that's what it's called in Colorado, um, attorney regulation, anybody that has a license, you want to get rid of the case before a jury ever has to make the decision because you don't want strangers involved in your life if you can avoid it.
So, James, here's where I want to wrap this up. What are the biggest mistakes people make when trying to explain that they were just defending themselves?
Well, I guess the best answer to that is very few people are objective enough to take a look at their own behavior, and they have to realize that their behavior is going to be looked at by somebody that is supposed to be objective. And oftentimes there are things that in their mind they don't recall, but someone else may recall. So it's better to let the objectives look at it. And if you need to, at some point, you can explain your position. But don't forget, usually when these questions are being asked, you're in a very high emotional state. You're angry, you're upset, and say, "Well, I was just defending myself. You know, she hit me first." Well, you're pretty angry, you're pretty upset, and your recall isn't going to be the same as it would be a day later. And there may be drugs and alcohol involved that won't be involved a day later. So the reason that it's best not to say anything is it takes all those subjective things out of your statement and allows you a day later, maybe 2 days later to sit down and say, "Okay, here's what I recall happening." And so, uh, that's why, in my opinion, it's best to, not talk to the police.
Thank you so much for your insights today. It's been eye opening for me, and I'm sure for our audience. And folks, thank you for tuning into Colorado Criminal Defense with James Colgan. For expert legal advice or to schedule a consultation, head over to jpcolganlaw.com. And remember to like, subscribe, and share the episode with somebody who may need it today.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.